The Supreme Court is upholding the right of voters in Michigan to ban race as a factor in college admission decisions.
It's a decision that's reigniting debate. NBC's Steve Handelsman has the details from Washington.
In a referendum in 2006, 58% of Michigan voters approved amending the state constitution to ban any consideration of race in public college admissions and public employment. At the Supreme Court today, the six-justice majority upheld that process. Justice Anthony Kennedy writing, "This case is not about how the debate about racial preferences should be resolved. It's about who may resolve it." The court did not rule on the constitutionality of affirmative action, but opponents are still celebrating.
Well, we live in a time with a black president, a black attorney general, when to make the kind of claims that people are being discriminated against and being prevented from entering into positions in a university or a job at a hospital or a public employment project simply no longer makes sense.
The NAACP says affirmative action is still needed.
Segregation and racial inequality exist throughout this country. In housing, we see it in employment, we see it in schools. And so that is something that must be addressed.
Justice Sonia Sotomayor agreed, saying judges ought not sit back and wish away racial inequality. And she said of the Michigan referendum, democratically approved legislation can still oppress minority groups. 8 states now ban consideration of race in admissions and hiring, and more states are now expected to ban it. I'm Steve Handelsman, NBC News, Washington.
The president at the University of Texas at Austin released a statement today following the Supreme Court decision. It says, in part, "We are reviewing today's Supreme Court decision, but based on our preliminary review, we do not believe it has any effect on the University of Texas at Austin's admission policies or our recent admissions decisions." You'll recall UT Austin has been battling a lawsuit over the admissions policy since 2008. Abigail Fisher was denied admission to UT Austin. She fell just short of the top 10% rule, then race plays a part of the admissions process. Fisher claims the university discriminated against her, violating the Equal Protection Clause. The case made it all the way to the Supreme Court, but then it was knocked back in June. Last November, the Fifth Circuit Court of Appeals came to Austin to rehear the case. Today, UT said they are still waiting on the decision from the Fifth Circuit.